All right, good afternoon. This is the Indiana Civil Rights Commission training on reasonable accommodation / reasonable modification and service animals in housing. My name is Kylie Kramer. I'm the Public Outreach and Education Manager in the External Affairs Department for the Indiana Civil Rights Commission. This is my colleague, Tracy.
I'm Tracy Richardson. I'm the Director of ADR and Staff Attorney with the Indiana Civil Rights Commission.
I would like to say thank you so very much for signing up today and attending the Indiana Housing Community Development Authority, IHCDA. Funded Properties Required Fair Housing Training today. This training is brought to you by the Indiana Civil Rights Commission in partnership with IHCDA. During today's training, I will call out 2 code words. Please write down those code words and any other information that you find helpful today. At the end of the training, an email will go out to the email address that you used to register for today. The email will contain a link that you will need to use to verify today's attendance. Please click on the link and enter in your information and the 2 code words from today's training. Follow up with Stephanie Sloan here at ICRC with any questions. Her phone number is 317-233-6144. Again, if you have any questions about the link, it is 317-233-6144. If you have any questions about that or would like me to repeat anything, please go to the Q&A section and you can anonymously send a message to me. With that being said, we're going to get into what we're going to talk about today, which is the ICRC mission, our jurisdiction, litigating with ICRC, the fair housing laws, the definition of disability, reasonable accommodation and reasonable modification, as well as service animals. So our enforcement areas here at the Indiana Civil Rights Commission are given to us under the Indiana Civil Rights Law, and that allows us to enforce equal opportunity in fair housing and housing real estate, employment, public accommodations, credit, and education. Our main purpose here at ICRC is to enforce, investigate, and educate. Those enforcements come from our laws that we follow, both federal and state, and they can also come through these trainings. Investigating comes through with a complaint and it goes through our whole process here at ICRC from intake to investigation and can fall into jurisdiction under Tracy with mediation. And then education comes from our external affairs department with me for your public outreach education with these trainings.
So basically our enforcement authority does come from Indiana state statute, our Indiana Civil Rights Law, which is 22.9. Our Federal Fair Housing Act 22.9.5, and we have our administrative authority, our guidance that comes from 910 IEC in the administrative code. Our enforcement authority applies to complaint filing. It applies to impartial investigations if we find a cause, whether it's probable or reasonable cause in the area of fair housing. We can go into litigation where we become an advocate and we will litigate on behalf of the public's interest. So we do have enforcement authority based on our statute. We can additionally mediate a complaint. We do at times when parties are agreeable, mediate, and that also may close out a civil rights complaint if an agreement is reached. Compliance obviously has to be reached as well. We do monitor for compliance where a settlement or a conciliation agreement is made. And again, as Kylie mentioned, again, by statutory authority, we have the mandate to educate the public, to make the public aware of the Indiana Civil Rights Laws and the Fair Housing Act that govern over the state of Indiana.
Moving forward, we want to go into the importance of this training and the Indiana Civil Rights Commission in general. This is a fair housing training strictly towards reasonable modifications and accommodations with service animals. And we find that this provides security, stability, and safety. These trainings also allow people to understand the importance of equal opportunity with social and economic mobility as well.
So it's important to understand that one of the guidelines for creating civil rights legislation was to ensure equal opportunity to individuals, and that's equal opportunity in many and really all of our enforcement areas. Our enforcement areas go from education to employment, obviously to fair housing, which we are discussing today. but it has been kind of shown that without the security and the stability, as well as the safety that fair housing provides, it's very difficult to achieve equal opportunity, whether it's in the job market or whether it's in other areas of public accommodations, credit. So that social and economic mobility becomes very difficult when there's not that equal opportunity for fair housing. We all kind of understand that safe housing or shelter is actually a need of human beings. So before you begin to discuss your civil rights and your needs as your desires as an individual for the way you want to live your life, it's important that you have those needs met. So that's one of the primary reasons the Fair Housing Act was founded and found to be an important component of civil rights legislation.
So moving forward with our jurisdiction, the Indiana Civil Rights Commission enforces the Indiana Civil Rights Law, the Indiana Fair Housing Act, as well as Title 910 of the Indiana Administrative Code. And under the Indiana Fair Housing Act, a person may not be treated differently because of their race, religion, color, sex, disability, national origin, and familial status strictly within fair housing. And today we're going to cover disability.
And again, when we talk about protected classes, this is what we're talking about. So unlawful discrimination obviously has to have a basis, and not just any kind of unkind behavior is what we deem discrimination, but it's behavior based on an unlawful reason. And those reasons are discrimination that is based on race, which can include all races. You can have file a discrimination complaint if you are Caucasian, if you feel you are discriminated against based on your race, but also association. Religion is what we deem a sincerely held religious belief. So it's not just one particular religion, it's that same right to religion, to religious exercise that all individuals have. So if you are being treated differently based on your religion, that is another basis for a complaint filing. Color can be unique to communities of color, where different shades of individuals from communities have experienced discrimination. That is discrimination that is under our jurisdiction. Color at times is added to a race discrimination complaint, but color in and of itself can be a basis for discrimination under our statute. Sex includes both sexes. It is not unique to females. Anyone can file a sex discrimination complaint based on their feeling that they are being treated differently because of their sex, or there's a policy that harms them because of their sex. It should also be known specifically within the context of fair housing. We do follow the guidelines from HUD regarding what constitutes sex discrimination. So anywhere HUD has said this may be a protected class under a fair housing statute, the Indiana Fair Housing Statute follows that guidance for a determination of what may constitute sex discrimination. Obviously, we have jurisdiction over disability complaint filings. We're going to go into that today, specifically with respect to reasonable accommodations and reasonable modification requests. National origin is also under our jurisdiction, as well as familial status, which is not under our civil rights legislation, but familial status is an added protected class in the area of fair housing.
Moving forward, we want to talk more into fair housing and who is not subject and who is subject to the fair housing laws. So properties owned and controlled by religious organizations, private clubs not open to the public, housing for older persons, the 62 and over and 55 and over rule. They are their own entity, but they also are no exemption from discriminatory statements or interference or coercion. These organizations still cannot have racially discriminatory practices.
So when people ask who's subject to the Fair Housing Act, we like to say that everybody is subject to the Fair Housing Act, because there are components of the Fair Housing Act that even your exemption may not exempt you from. And as Kylie mentioned, racially discriminatory practices, discriminatory statements, interference or coercion. There's a list of exemptions within the Fair Housing Act that discusses all of the types of property owners that are exempted. Property does have to be a dwelling for use of fair housing in order for it to fall under our act. But even again, if you meet one of those exemptions, there are other areas where liability can be attached or a complaint can be filed. So if you are a provider of fair housing, or if you are an entity that deals with residential real estate, it is important that you have a broad and complete understanding of the Fair Housing Act, and that you train your staff in the Fair Housing Act to ensure that your policies and your guidelines are in line with state law.
And just as Tracy said, when we're looking at the fair housing laws, it's truly everyone's a person. It's everyone who is subject to it. We're really looking at sellers, landlords, leasing agents, homeowner associations, realtors, mortgage providers, and individuals in general with discriminatory statements.
So yes, those are the primary, within the Fair Housing Act, the primary types of providers that complaints are filed against, but business entities, corporations, partnerships can also be under the Fair Housing Act. And as we talked about, there can be individual liability because the Indiana Fair Housing talks about coverage over a person. So, and that person is defined in a very broad way. So again, if you are in the business of providing housing or in residential real estate, it is very important to understand the Fair Housing Act and to train your staff in these laws in order to avoid having complaint filing or liability.
And quickly, we want to go over who can file before we move forward. So any aggrieved person can file a complaint with ICRC. This is anyone who can show that they have been or will be injured by a discriminatory housing practice. And this may include from fair housing organizations, testers, individuals of any race, and employee of fair housing provider as well.
Yeah, just to touch on that, an aggrieved person is an individual who feels that they've been harmed by an unlawful discriminatory act based on one of our covered protected classes, by their protected class status. So any of those individuals, and those individuals do, the courts have found that that does include fair housing organizations anytime that they have to expend funds or work over and above their mission in order to assist an individual who has faced unlawful discrimination. So those organizations have been found to have status and standing that a harm can be shown, and so liability can be found. Testers, the same thing, even though their intention individually was not actually to seek out and gain fair housing. The courts have attributed other areas of liability with the specific types of complaints. And a tester being told that property is unavailable when it actually is, that is the harm in and of itself. A court would make a determination on the value of the harm. But again, when a complaint is filed with the Indiana Civil Rights Commission and there's a finding of cause, the Indiana Civil Rights Commission becomes the complainant, and we are moving forward based on the public's interest, and that is what we are vindicating. So individuals of any race, employees, and want to quickly touch on that just because an employee of a fair housing provider, residential real estate transaction provider, if they are attempting to operate within their employment within the guidelines of the Fair Housing Act, and they are being pressured or told to do things that could or have been shown to be unlawfully discriminatory and could run afoul of the Indiana Fair Housing Act, and there is some type of retaliation, whether it's discipline or firing, that employee can file a complaint. They can file that retaliation complaint under our statute. We have jurisdiction under that circumstance. So not only is it important that you train your employees on the Indiana Fair Housing Act, it's important that you encourage them to follow the Indiana Fair Housing Act and that you're not attempting to circumvent it or enact policies that deviate from it.
So we're going to go into now the disability portion and explaining this with definitions and examples. So if you have any questions about the Indiana Civil Rights Commission, our jurisdiction, things of that nature, please be sure to drop that in the Q&A section as well, and we can go into depth with that later. So the definition of disability, the Federal Fair Housing Act defines handicap as a physical or mental impairment that substantially limits one or more major life activities. So going off this with the Indiana Fair Housing Act, through the Indiana Administrative Code, similarly defines disability as a physical or mental impairment which substantially limits one or more major life activities, a record of such an impairment, or being regarded as having such an impairment. So we're going to take a second here to quickly allow you just to absorb that information. Again, if you have any questions, comments, or concerns, please drop that into the Q&A section. And while you are here, I know some new people logged on as well. We do have 2 code words to prove that you have been participating and logged into this training today. So make sure to write those down. I will not be saying them all at the end. Your first code word, and this is the only time I will say it during this training, your first one is testers. Your first code word is testers. Make sure to write this down, as you will receive an email from the Indiana Civil Rights Commission at the end of this training to prove that you have done this training. And we're going to move forward. So reasonable accommodation. So the definition is a change, exception, or adjustment to a covenant, rule, policy, practice, or service that allows a person with a disability equal access to use and enjoy a dwelling, which includes public area and common use areas. So examples of an unreasonable accommodation could be providing forms in large print, providing a designated accessible space near a resident's rental, and allowing a resident to have a service animal in a no pets building.
So with respect to reasonable accommodations, it's important to note, often when we get a complaint filing and we get a response or an answer from a fair housing or housing provider, they sometimes say, well, I let my tenant know I don't grant reasonable accommodations. It's the law. There's not, wiggle room with respect to doing that. Right that an individual with a disability has to a reasonable accommodation is not only based in Indiana law, but it's also based in federal ADA legislation. So if you have a tenant that has a disability, or they have a child that has a disability, someone living with them with a disability in your property, and there's been a request made and it is found to be reasonable, and it's an accommodation from some type of policy that you might have for the general public or the general use of your tenants, that is something that you have a responsibility to engage in a conversation to make a determination as to how you can reasonably grant that accommodation. It's important that you understand, again, that once you have that information, you are required to engage in conversations to make a determination as to how that accommodation can be brought about. It is not always a requirement that the exact specific accommodation is granted, provided that what can be granted. And we're going to talk more about some of the guidelines as to what the courts look at as to whether a reasonable accommodation request has been made and whether there's some liability on the part of the provider too or not to have followed through and provided it. But it's also important for providers to understand that those requests don't have to come in a specific form. We had providers that say things like, well, it wasn't on my reasonable accommodation form, therefore that tenant did not make a reasonable accommodation request. The courts have stated the form cannot be the only way a request can be made by a tenant. It's good to have a reasonable accommodation form. That's a great way to follow through and ensure that it's documented, that the conversations and the requests are being held. But a tenant is not required to utilize a form. A tenant is not even required to have made the accommodation request in writing. So also tenants are not required to use magic words, reasonable accommodation, or I have a specific reasonable accommodation request. And that is because there are some tenants that simply don't understand that what they are requesting is a reasonable accommodation. But once a housing provider is on notice and is aware that they have a tenant that does have a disability, and that there is some type of request from one of their policies in order to assist that individual to equally have access to their fair housing, in order to ameliorate and assist and kind of keep that disabling condition from preventing them from enjoying fair housing, then a fair housing provider does have an obligation at that point to begin to engage in those conversations to make a determination as to how to grant a reasonable accommodation request.
So the difference between reasonable accommodation and modification is that a modification is a structural change made to a living space or to the common areas of a community, which is necessary to enable a tenant with a disability to have equal access, full use of, and enjoyment of the housing. So this could be something like widening a doorway, installing a grab bar in the bathroom, lowering kitchen cabinets to the height suitable for a wheelchair user, adding a ramp and handrails to make primary entrance accessible, altering the walkway to provide access to public or common area use.
And so the courts have found that with respect to reasonable modifications, that it is not a violation to have the requester bear the burden in a majority of the instances of the modification request. Additionally, if it is the desire of the housing provider to have the housing placed back in the situation or the order that it was prior to the modification at the requester's expense. So that's not been found a violation. There are some housing providers particular housing providers that receive federal funding that may be required to bear some of the costs of reasonable modifications. But again, that modification request is generally based on a need to condition that is preventing an individual with a disability from being able to use or enjoy fair housing in an equitable way with as other tenants enjoy it. So again, the same way those reasonable accommodation requests, once it's known that that individual with a disability has a need, and they've made it clear that they would like an accommodation or a modification, the same way those discussions need to begin to find out what can reasonably be done.
And so you touched on this very well in the previous slides. As you were saying with modifications, they don't need to use the magic words. It may be verbal or in writing, and they cannot require it to be in writing or on their forms that they were saying. Requires housing provider to engage in conversations regarding the appropriate accommodation. All of this has to do regarding with requesting a modification, and Tracy hit on all of that.
And some of the questions that come up are about verification, and there are some distinctions between individuals that have clear disabilities that can be seen. When there are individual disabilities, a housing provider can get more information, and that information again is for the purposes of making a determination of a request that would be reasonable. I think we can go on.
Yeah. So potential defenses, generally a housing provider should provide an accommodation if it's deemed reasonable. Courts have found the following instances to not be reasonable. The request fundamentally alters a program. It imposes an undue financial burden or administrative burden. The cost can occur as long as it is not an undue burden. Request poses as a direct threat results in substantial physical damage unless the threat can be eliminated by a reasonable accommodation.
So it's better for a housing provider not to look for ways not to provide an accommodation request because the majority of the requests simply won't alter your program or prevent you from continuing to be a housing provider, providing a parking space. Obviously won't stop you from being an apartment building that houses individuals as tenants. An undue financial or administrative burden, the courts would kind of look at financial records to see what type of modification or accommodation is being requested. Studies have shown that a vast majority of the accommodation requests at least are minimal financially. And again, there's case law that supports the requestor when needing a modification bearing some or all of the cost of that modification and the cost of returning that property to the state that it was in prior to the modification, if that's what the housing provider prefers. So that undue burden standard, and again, a direct threat as well. There is an analysis based on whether or not that accommodation would pose a direct threat to other tenants. That has to be a real threat, not a perceived or again, something based in a stereotype, but an actual threat. But where that can even be eliminated by another reasonable accommodation, there may be a need to provide that accommodation as well.
So, and you were just talking about verification, but when is it appropriate to request a verification? So if the disability is known or should be known and the requested accommodation is related, no verification is necessary. If the disability is known, but the requested accommodation does not appear related to the disability, if neither the disability nor the relationship between the disability and the accommodation is clear.
And verification can take many forms. And it's important to note that a court may hold that a housing provider already had verification and perhaps a doctor's note wasn't necessary if perhaps the housing provider was aware of the disability, perhaps was aware of maybe the healthcare provider knew the healthcare provider, or if the housing provider knew that individual with a disability was on some type of Social Security income because they utilized it as income verification to apply for that particular property. But there's not one particular way to verify that there is a disabling condition that requires an accommodation. So you want to be careful. You don't need to ask a specific disability. What is more important is to find out what that disabling condition is and what can be done again to ameliorate that disabling condition that would allow that individual with a disability to have equal access to the use and enjoyment of your property. And again, that starts with conversations. It's very important that those conversations are held. So what really needs to be done is clear. Often housing providers hear a request for disability and kind of run because the first thing they're thinking is someone is going to ask for an extraordinary amount of money or some type of extraordinary change that's going to create a great deal of problems. But you are far better off beginning and engaging in the conversations to find out what is actually needed.
And Tracy did talk about this a little bit with who pays and the difference between both modifications and accommodations. So with accommodations, Housing providers may not require individuals with disabilities to pay extra fees or deposits as a condition of receiving a reasonable accommodation. As far as modifications, generally, tenant will bear the expense of making reasonable structural modifications to a property. If the property receives federal funds, housing provider may be required to pay.
And so with respect to accommodations, the biggest area that we kind of see housing providers attempt to require individuals with disability pay extra fees is with either emotional support animals or service animals. Housing providers may attempt to require a higher security deposit or may even make monthly rent higher. That is not appropriate under either the Indiana or the Federal Fair Housing Act.
Housing providers should follow both the Fair Housing Act guidelines as well as the Americans with Disability Act guidelines for reasonable accommodation requests of the use of a service animal, which is what we will be getting into. This is just a case talking about reasonable accommodation and reasonable modification.
And the discussion and the point we were making here, and we've discussed before in some of the trainings, is a lot of times housing providers may believe that if they did not have some type of intent to discriminate, that will keep them from liability. And that's simply not true, particularly in the area of reasonable accommodation denials and reasonable modification denials, where they were found that the requests were reasonable because you may feel that you engaged in a good faith effort but made a denial that wasn't shown to follow any of the guidelines that allow for a denial of a specific request. That is not necessarily true. If you should have granted that accommodation, you could find yourself liable. So again, even though there's not that absolute requirement to give whatever request is made, it is important to do that determination as to whether that request is reasonable, if it is not an undue financial or administrative burden, if it is not changing the scope of your business and it's not a direct threat, then it more than likely granting that request may be found reasonable. Again, if it sort of ameliorates the effect of that disability and allows that individual equal access to the use and enjoyment of your housing.
Restoration from a reasonable modification. So housing providers may choose to keep the modifications in place at the end of a tenant's residency, as these changes may be enhancing the general accessibility of the unit or common area. Tenants are obligated at their expense to restore to the previous condition, or the housing provider requests the restoration. And now we're going to get into service animals. So again, if you do have any questions about what we just talked about with reasonable accommodations and reasonable modifications, please put that in the Q&A as we are moving forward with service animals. So the definition of a service animal is a dog or miniature horse that is individually trained to do work or perform tasks for people with disabilities. Assistant animal requests are assistant animals, which include service animals, is a request for a reasonable accommodation under both the Indiana and the Federal Fair Housing Act. The same guidelines for approving reasonable accommodation requests should be followed. Failure to accommodate a request for a service animal is a violation of the Americans with Disabilities Act. Would you like to expand?
So it's just kind of important to note that service animals specifically have some rights. Protected individuals have rights protected with respect to their service animals under the Americans with Disabilities Act. But with respect to fair housing specifically, we kind of talk about all assistance animals because some individuals have service animals, which kind of have a higher level of right with respect to having that animal with them. They can take that animal with them places that generally where animals would not be allowed, such as public accommodation areas. So that right is a bit stronger. We have in Indiana ESA legislation regarding emotional support animals. That would generally be an accommodation request in a property where pets weren't allowed. And just as we've discussed, you couldn't require an extra fee if that is found to be a reasonable request for someone, even in a no pets building, to have their emotional support animal. Housing provider is not, should not under the Indiana Fair Housing Act guide or require additional fees because that is a prescription for that individual, and that is again to ameliorate the effects of that individual's disability, to give them the use and the enjoyment of fair housing. Of course, just like any other reasonable accommodation request, if a request such as that is made and there's not a clear understanding of the necessity of the use with respect to the service animal, a housing provider may ask questions and engage in some dialogue to ensure that the granting of that request is reasonable under their specific circumstances. With a service animal, the only real questions you can ask regarding the service animal is if that animal is required due to a disability and what work that animal performs. And when an individual has a service animal, they have the right to have that service animal with them. So again, additional fees, that type of thing should not be charged.
And some example of service animals include alert dogs for those with a hearing impairment, seizure alert dogs, and guide dogs for those with visual impairment as well.
Yeah, and there are some psychiatric service animals. They are different from emotional support animals, so it's important to make that distinction. If it is a psychiatric service animal, then they have kind of a different reasonable accommodation question than just an emotional support animal, because they, again, they are to do work specifically for that individual's disabling condition, as opposed to providing necessary comfort that a service animal provides. But again, it's a different level.
So housing providers should not impose breed, species, size, or weight limitations, require that the animal wear a special harness or tags, require third-party certifications or registrations, require fees, extra rent, or deposits, just as Tracy was saying, require the animal have special trainings, require veterinary or vaccination records, require the animal to be spayed, neutered, declawed, or microchipped, require burdens of paper or affidavits. Sorry, no, I'm getting that one wrong. Refuse assistance animals because of staff's or neighbors' fears or allergies, and require that the person with the disability is the only person allowed to handle the animal.
Yeah, there are some, and we're going to talk about them in a minute, some responsibilities of handlers of service animals or individuals that have emotional support animals or other assistance animals. But when we talk about breed, species, size, and weight limitations, we know a lot of housing providers have those generally, but when it comes to that service animal, if that individual has a service animal and that's a specific animal, there should not be any kind of restrictions placed on that animal, because that animal has indeed been trained to do some kind of work that assists that individual with that very specific disability or disabling condition.
And someone just asked, are they subject to the same vaccination rules? And if you can deny that they do not follow those rules, and we just.
And we're going to go, I think our next slide kind of talks about that a little.
Yes.
Or maybe the slide after this one.
So that will answer this question. The handler guides. So handler must supervise the animal. They must be responsible for meeting all vaccination, registration, and licensing guidelines. Handler does not have to register the animal as a service animal, and the handler must keep the animal under control at all times as well.
So the guidelines that all animals, if animals are allowed on that property, have to follow with respect to vaccination, registration, or licensing would have to be shown, but not some type of specific guidelines because we're allowing a service animal on the property when again, it is a right and it's used. I think they should have this type of vaccination, or I think they should have this type of registration. It's important to understand there is no service animal registry. So there is no service animal vest you could have an animal that says they're on the registry and says they have a vest, and you should know that more than likely may not be a service animal because those don't exist. And individuals with disabilities that utilize service animals know that they may have a vest on their animal for other purposes or to assist other individuals understand they're utilizing a service animal. But when people start talking about he's registered, there is not a registry. There are a lot of guidelines for service animals. Individuals are allowed to train their own service animals. They can utilize the type of training that they choose as long as it's appropriate for the disability related need. And so trying to verify a service animal is beyond that housing provider's scope.
And Fair Housing Act with service animals does not distinguish between service dogs and emotional support animals. A reasonable accommodation request may include requesting an emotional support assistance and or service animal. So this is the case in which Indiana Courts of Appeals determined that it is important for both a housing provider and attendant to engage in the interactive process, which is what you touched on.
So yeah, we were talking about that again, once it's pretty well known that a reasonable accommodation or even a reasonable modification request is being made, it's not only important for the housing provider to engage in conversations, but it is also important for the tenant to engage in conversations and give information that they can as well, so that both the provider and the tenant can come to an agreement on the reasonableness of a request.
And this kind of goes along with what Tracy was hinting at earlier with service animals. A request may include a guide dog or seeing dog, a hearing or signal dog, a mobility assistance dog, SIGS dogs, which is social signal dogs, alert/response dogs, psychiatric service dogs, and miniature horse. And we want to ask you this, and please respond in the Q&A section. Which question is inappropriate to ask someone? Is it A, the animal, is the animal required because of a disability? Is it B, what work or task has the animal been trained to perform for you? Or is it C, what is your disability? We'll give you a second to answer that in the chat. So we have gotten some already, and you are correct if you have answered C. You cannot blatantly ask someone, what is your disability?
Again, the appropriate response is particularly with respect to a service animal. Is the animal required because of a disability, and what task has that animal been trained to do? And again, even with an ESA or an emotional support animal, the real question is, what is the disabling condition? It's not generally necessary to know the exact disability. You don't need to know the exact disease or diagnosis, but what you do need to understand is, what is the condition, what is the difficulty that the accommodation request would assist in order to grant that individual with that disability equivalent access to the use and enjoyment of your housing. And again, these requests are not for rights that are over and above any other individual, but under the ADA and under the Fair Housing Act, legislation was formed to protect individuals with disabilities. And it is important that those disabilities are accommodated when necessary, the same way we want to provide any individual of a protected class with access to fair use. We don't want to have the notion, kind of the same way we discuss with discriminatory statements. We don't want to give individuals an ideal that individuals of their protected class are not preferred in your housing. So if it becomes very difficult to almost impossible to use or enjoy housing because of a disabling condition that could be remedied with a reasonable accommodation, that gives off the notion that there is a particular class that's not preferred or favored. And so that's not something that you want to do. Again, it is a right. Those are rights to reasonable accommodations granted, again, both under the ADA and the Fair Housing Act. So it's important that fair housing providers understand them when they hear them, that they acknowledge them when they hear them, that they acknowledge that a request perhaps is being made, even if it's not on a specific form or in writing. Now, there's nothing wrong. It is not a violation to request that it be done in writing. It's actually, again, has been stated to be a good idea to have it documented so that it can be followed through with, so that it's clear what is needed, but it is not a requirement on behalf of that individual making that reasonable accommodation request or reasonable modification request.
So we're going to take a quick minute and allow the questions to kind of come in as we are about to enter into our Q&A session. Please ask any questions that you would like more explanation or an in-depth analysis in. Again, we are going to give the disclaimer that we are not giving out legal advice. This is just for educational purposes. So we'll be back in a second. All right, we are back and we got some questions. And before we enter into that, we want to talk about prevention, which is the biggest takeaway. So that is just knowing and following your fair housing laws. Housing providers should know their responsibilities under the Indiana Fair Housing Act. They should train their employees on the Indiana Fair Housing Act to prevent such cases from starting. They should comply with all fair housing posting requirements and should include policies in the tenant lease agreements.
Yes, it's very important that housing providers have a good understanding of the laws that govern their business. You would be surprised at the number of housing providers that actually provide us information that shows some type of violation without an understanding that a policy that they perhaps have in place or statements that they've made or policies that they kind of follow informally are actually violations of the Indiana Fair Housing Act. And we find that many providers don't do that intentionally. They do that because they are not aware of what the laws and the regulations are. So really important that not only providers know those laws the same way you understand those landlord-tenant laws, but also that you train your employees to know those laws, because some of the behavior that your employees may be engaging in could be obviously attributed to you as the employer. So training and knowledge, it is obviously important that providers comply with advertising and posting requirements and guidelines. That helps not only staff and ownership, but other tenants that may have business with you to be able to keep in mind, and again, you as providers to keep in mind that we do provide fair housing. We are an equal housing opportunity provider as is required by law, and that we're going to continue to follow those laws. We're going to have those laws in place. We're going to make sure our policies reflect equal housing opportunity, to kind of keep that uppermost in your mind as you go about your daily business. We may have briefly touched on some implicit bias, but we find again that often there is not that intent to discriminate. It may be a natural reaction based on some implicit biases. So having policies in place that prevent that from occurring can be very helpful. And finally, housing providers, yes, should have those policies and tenant lease agreements. Other tenants should have an understanding that they can come under the jurisdiction of the Indiana Fair Housing Act as well. And they should understand there are certain behaviors, particularly with respect to perhaps discriminatory statements or harassment, interference, or coercion, that they should not be engaging in. If there are issues with other tenants, perhaps there's a process in place to resolve tenant disputes, but tenants should understand, and there should be policies in place that show that you are an equal housing opportunity provider, that you are a fair housing provider, and that you will not be tolerating that type of behavior from tenants, because that will keep you from having liability assessed against you as a fair housing provider.
Well said. And we are going to enter into our Q&A session. Before I do so, your second code word that you will need to provide in the email that you will receive at the end of this is horse. Your second code word is horse. And so we do have some questions here, some really good questions. So the first one, can an individual have more than one service animal?
Well, if an individual has a service animal for a specific disabling condition, that's an analysis and that would be made as to whether or not that was a necessity by a court. But if you meet the rationale and the guidelines for a service animal, it could be, particularly for more than one disabling condition. Those instances have occurred.
We have another question. Are there differences between service animals and emotional support animals in regards to where they are allowed in the common areas with the handler?
Generally, the primary difference is with a service animal, an individual has a right to have that service animal with them at all times. So in public accommodation spaces, common spaces, an individual with a service animal would be allowed to have that animal with them. With respect to an emotional support animal, an emotional support animal is going to be specific to provide that emotional support for a particular disabling condition. So there's going to be an analysis as to the necessity in certain environments. Of course, the environment of their home or their apartment in and of itself, that and that kind of analysis has already been done. But if there's not an analysis or a need that's been discussed with respect to common areas, that would be open to discussion as to whether or not that would be reasonable.
And then our last question, has any type of animal ever been denied as an emotional support animal?
Well, I'm not quite sure that question, because obviously denials occur. Whether or not the denial was appropriate, that would come before us in the form of a complaint. They may wonder, has there ever been an appropriate denial? Again, the reasonable accommodation analysis comes into play. And so if you have an accommodation request, it is based on a disabling condition. That request does not pose a direct threat that could not be ameliorated with another reasonable accommodation. If it does not impose an undue financial or administrative burden, if it is not changing the nature of the provider's business model or business structure by granting the request, that's the same type of analysis that the court is going to make with respect to that emotional support animal request. And so depending on how those questions are answered, we'll make a determination as to whether or not a denial or a granting is appropriate.
I think those are all great questions. And I want to thank you all for coming today and signing up for this training and listening in and asking some really great questions. If you have any questions regarding trainings or anything of that nature, my cell phone number and my email are up and displayed. If you are trying to get in contact with the Indiana Civil Rights Commission, our number is 317-232-2600, and that is our website if you are trying to request trainings or things of that nature. Thank you so very much for coming today. If you have any other questions, we'll keep the Q&A open for a few more minutes. Thank you, Tracy, for being here today, and thank you so much for participating today.